Thank you, Mr. Seaton. Your Excellencies, Minister of Government, distinguished colleagues, distinguished guests, students, ladies and gentlemen. It's great to be back in St. Kitts and to see familiar faces once again. I'm going to be brief, and my colleague is going to be long. My topic is the linking from the Privy Council and accepting the appellate jurisdiction of the Caribbean Court of Justice, the mechanics of judicial emancipation. And I should start by saying that I feel somewhat surreal appearing before you to argue for acceptance of the Caribbean Court of Justice, CCJ, by St. Kitts and Nevis. It's a bit surreal because just a few short months ago, the President of the UK Supreme Court, Lord Nicholas Phillips, famously warned that Caribbean appeals to the Privy Council were using up too much of the time of his judges and too much of the taxpayers' resources, and that Caribbean countries should consider using their own regional court. These words still ring in our ears, still reverberate in our public discourse, and still undermine our declarations of nationhood. But my feeling of unreality in having to consider the case for the CCJ is also due to two other factors. First of all, the participation by St. Kitts and Nevis in the establishment of the CCJ. As a founding member of the CCJ, St. Kitts and Nevis is as responsible as any other Caribbean state for the existence of the court. St. Kitts and Nevis took a leading role in negotiating and was among the first to sign the agreement establishing the court in 2001. St. Kitts and Nevis was also a prime mover in negotiating and adopting the revised agreement establishing the Caribbean Court of Justice Trust Fund. Together, the CCJ agreement and the revised Trust Fund agreement, which have both been incorporated into the laws of St. Kitts and Nevis, contain procedures for the appointment and security of tenure of the judges of the court, and for securing an independent source of funding for the court in perpetuity. It is fair to say that these agreements represent an unprecedented and a far-reaching attempt to insulate the court and its judges from the possibility of executive interference. And St. Kitts and Nevis was, of course, fully represented at the inauguration of the court in Port of Spain, Trinidad, on 16th April 2005. That inauguration remains a seminal event in the administration of justice in the Caribbean, because the CCJ is undoubtedly a Caribbean institution. It is a court of our making and of our ingenuity, and the envy of countries and regions around the world, because of the unique arrangements which have been made to insulate the court from the possibility of political interference. Secondly, discussing the acceptance of the CCJ also has a feeling of the surreal about it, because the court is up and running and making decisions that affect every person in this room, and indeed every person in the Federation of St. Kitts and Nevis. I'm now speaking of the court in the exercise of its original jurisdiction. Like the other 11 member states participating in the CSME, St. Kitts and Nevis has accepted the original jurisdiction of the court to hear and determine disputes arising under the revised Treaty of Chaguaramas. St. Kitts and Nevis can sue and can be sued in the original jurisdiction. Anyone in this room who claims that his or her treaty rights have been infringed can in fact take their case today before the CCJ. And these rights might relate to the right to migrate regionally to seek employment, the right to move your goods that you have manufactured freely throughout the region, the right to establish a business in any Caribbean jurisdiction of your choice, the right to provide services, and the right to move your capital. As the CCJ emphasized last year in cases brought in the original jurisdiction, it is prepared to make findings of unlawful conduct against member states and against the community where such conduct infringe the rights of community nationals. The court was at pains to point out that unlike the prior dispensation, the CSME was now operating under a rules-based system. Accordingly, all that remains for St. Kitts and Nevis is the question of joining the appellate jurisdiction, where the decisions are taken by the same judges exercising the original jurisdiction, instead of continuing with appeals to Her Majesty in Council, that is, to the Privy Council in London. It has to be said that St. Kitts and Nevis is not alone in not yet having taken this final step towards the full emancipation of the judiciary. As of today, nearly 5 years after that red letter day of the court's inauguration in Port of Spain, only 2 Commonwealth Caribbean countries have delinked from the Privy Council and joined the appellate jurisdiction of the CCJ. Barbados did so in 2005, and Guyana also in 2005. Happily, whilst Professor McIntosh and I were in Belize in March of last year, 2009, the government announced that it would be joining the appellate jurisdiction of the court, due largely to the speech given by Professor McIntosh. And earlier this year, January 2010, the government passed legislation to this effect. So we're now waiting for the legislation to be brought into force to effectuate the joining of the CCJ by Belize. So it is crucial, I think, that we examine again the position of St. Kitts and Nevis towards the court, lest whatever momentum was generated by the events of 2005 be lost to us for another generation, unless the descendants of our former colonial masters again inquire of our loitering on the colonial steps after ours. At this point, it might be useful to remind ourselves, if only briefly, of some of the arguments in favor of St. Kitts and Nevis' repatriation of its final court. And I'll mention them very briefly. First of all, treaty commitment. St. Kitts and Nevis has a sacred treaty commitment to consider favorably the entrenchment of the Caribbean Court of Justice in its constitution. Having affirmed the role of the court in developing regional jurisprudence, the parties to the CCJ agreement, including this country, St. Kitts and Nevis, then expressed themselves as, quote, convinced also of the desirability of entrenching the court in their national jurisdictions, national constitutions. Furthermore, in the revised treaty establishing the CCJ Trust Fund, the parties, again including St. Kitts and Nevis, expressed themselves as recognizing the critical role of the court in the efficient administration of justice in the territories of the contracting parties, end quote. The second category of matters has to do with the financial implications of establishing and operating the court. St. Kitts and Nevis is currently paying good money for a court that it is not fully using. This country pays 2.11% of the US $100 million used to capitalize the CCJ Trust Fund. In other words, the government of St. Kitts and Nevis has, through agreement with the Caribbean Development Bank, arranged to repay on an annual basis and is currently servicing a total loan package of $2,110,000 US to the CCJ in the first instance. I say in the first instance because the CCJ agreement obliges member states, including St. Kitts and Nevis, to increase their future contributions should the resources in the fund prove inadequate to support the court. This applies whether the member state is using both the original and appellate jurisdictions, as does Barbados and Guyana, and soon Belize, or is using only the original jurisdiction, as does St. Kitts and Nevis. The third category of arguments in favor of accepting the appellate jurisdiction of the CCJ follows on from the acceptance of the original jurisdiction. As a party to the revised CARICOM Treaty, St. Kitts and Nevis is already bound by the original jurisdiction. Article 211 of the revised treaty provides that parties recognize the compulsory and exclusive jurisdiction of the court to hear and determine disputes concerning the interpretation and application of the revised treaty. As foreshadowed in my earlier remarks, the court has already heard 3 cases in the original jurisdiction. 2 survived the jurisdictional stage and went on to be decided on the merit stage. All 3 cases were brought by private entities. The first case, Trinidad Cement Limited and TCL Guyana against the Cooperative Republic of Guyana, 2009, held that a member state had breached its treaty obligation towards the applicant, who was a manufacturer of cement for sale in the region. Guyana had breached the applicant's treaty rights by allowing in cement from outside the region without imposing the Common External Tariff, the CET. However, the company actually lost on the merit stage because it did not establish that it had suffered loss as a result of the breach by Guyana. A point of considerable interest is that which concerns the finding by the CCJ that a company could sue the state of its nationality in the original jurisdiction without any prior litigation in the local court. So it means that if it's a company represented here tonight and it has a dispute with the government of St. Kitts and Nevis, it can in fact take that dispute, provided it concerns the CSME, directly to the original jurisdiction of the CCJ, even though this country has not yet accepted the appellate jurisdiction. The second case, Trinidad Cement Limited against the Caribbean Community, concerned the allegation that the community had acted ultra vires by allowing a waiver of the CET. And the applicant said that the community had acted irrationally, acted outside of its powers. The court was emphatic that it had competence to exercise the power of judicial review over CSME decisions taken by the community organs as well as community officials. At the merit stage, however, the court found that although there had been some procedural irregularities, the applicant had not proven that the decision was actually ultra vires. And the third action was against the community institution, Doreen Johnson against Caribbean Center for Administration Development. This failed at the jurisdictional stage because the court held it had no competence over the institutions of CARICOM as distinct from the organs of CARICOM. The point I'd like to emphasize is that there is a significant legal difficulty with being bound by the original jurisdiction while abstaining from the appellate jurisdiction. The difficulty arises from the referral obligation. Article 214 of the revised treaty obliges national courts and other tribunals to refer all issues involving the interpretation or application of the treaty to the CCJ for determination before delivering judgment. This is very similar to the preliminary reference procedure provided for in the treaty establishing the European Union. And Article 214 was discussed extensively last year in a case in Antigua and Barbuda, Lennox Linton against AG of Antigua and Barbuda. Now, this referral procedure poses a difficulty because if a national court in St. Kitts and Nevis does the referral and applies the determination of the CCJ, there is nothing to prevent a dissatisfied party from appealing ultimately to the Privy Council. Any decision by the Privy Council will be binding on St. Kitts and Nevis in the normal way, but this could clearly frustrate the object and purpose of the system of referral, which is to ensure a uniform interpretation by the CCJ of the provisions in the revised treaty. It is also possible to envision a situation where a local court or tribunal in St. Kitts and Nevis decides to make a reference to the CCJ, but that decision is appealed successfully to the Privy Council. It is therefore my respectful opinion that retaining appeals to the Privy Council whilst accepting the CCJ's original jurisdiction is inconsistent with and could likely frustrate the smooth working of the CSME. There is a fourth category of arguments in favor of accepting the CCJ, which are substantive policy arguments. However, these have been argued for so long and are so persuasive as to be impatient of any prolonged debate. Suffice it to say, it is now beyond argument that the Caribbean has jurists of sufficient competence and integrity capable of serving at the highest level of our court system. I believe Professor McIntosh will expand on this point much more shortly. What I would say is that the court is already performing its role in the development of Caribbean jurisprudence, both in the appellate jurisdiction in respect of cases from Barbados and Guyana, and in the original jurisdiction, as I've just suggested. And I should mention here as well that on the 5th anniversary of the court's inauguration, 16th of April this year, as next month, we're going to be having a special symposium in Trinidad and Tobago. And on that occasion, the president of the court, President Michael de la Bastide, will be giving a lecture, 5 years of CCJ's contribution to the jurisprudence of the Caribbean. Very, very important lecture to which you're all invited. So we come directly then to the central issue. What are the technical requirements for St. Kitts and Nevis to delink from the Privy Council and accept the appellate jurisdiction of the CCJ? The constitutional provisions concerning the establishment of the judiciary and for appeals to Her Majesty in Council are contained in Chapter 9, Articles 96 to 99 of the St. Kitts and Nevis Constitution and the Supreme Court Order. These are the provisions that will have to be altered for the patriation of our highest court, and there are 2 stages to this process. The much criticized case from Jamaica, Independent Jamaica Council for Human Rights against Marshall Burnett, 2005, outlines these 2 stages to the migration from the Privy Council to the Caribbean Court of Justice. The first stage is that of delinking from the Privy Council. The second stage is that of accepting the CCJ in its appellate jurisdiction. Whilst this 2-stage analysis does not, for reasons to be shortly explained, have the same resonance in St. Kitts and Nevis as it did in Jamaica, it remains a useful exposition of the process of judicial emancipation. So the first stage, delinking from the Privy Council. There is already OECS precedent on successful delinking from the Privy Council. In Mitchell against DPP, 1986, the post-revolution Parliament of Grenada had passed legislation confirming the termination of Privy Council jurisdiction over the PRG regime. This legislation was challenged on the grounds that it had not validly amended the provisions of the West Indies Associated States Appeals to Privy Council Order 1967, and thus could not terminate the Privy Council's jurisdiction. In particular, the applicant complained that there had been no referendum as required by the Grenadian Constitution to amend the Order of 1967. The Privy Council held that a referendum was not necessary to amend the Order of 1967, since the Order had itself removed this requirement by leaving the procedure for the amendment to the Constitution of the individual country. Amendment of the Grenada Constitution by legislation was a valid constitutional amendment under the entrenching provisions of the Grenada Constitution. And that Mitchell case, of course, was upheld, reaffirmed recently in Bernard Court against AG 2007. The Marshall Burnett case 2004 from Jamaica also confirms the Privy Council's willingness to sanction the abrogation of its jurisdiction. In this case, the Judicial Committee accepted that the provisions of the Caribbean Court of Justice Constitutional Amendment Act 2004 were sufficient to terminate its jurisdiction. The amendment procedure was relatively straightforward, since the Privy Council jurisdiction was not entrenched in the Jamaican Constitution other than minimally. Passage of ordinary legislation with a simple majority of the members of the House was therefore sufficient for the linkage in that country. Had the Jamaican legislature stopped at this point, it appears that the Privy Council would have been duty-bound to have found that it had been fired and its services no longer required. The difficulty perceived by the Privy Council related to the simultaneous attempt by the Jamaican Parliament to accept the jurisdiction of the CCJ, an issue highly relevant to the second stage. So the second stage, acceptance of the CCJ's appellate jurisdiction. The Marshall Burnett case ruled that the constitutional abrogation of appeals to the Privy Council may not be sufficient to enable a CARICOM member state to accept the appellate jurisdiction of the CCJ. Although the decision is not altogether clear, it seems that the Privy Council held that the legislature must go further and either one, establish the CCJ in its constitution with the kinds of entrenched constitutional protections and guarantees enjoyed by the judges of the Supreme Court, or two, establish the CCJ by a legislative process adequate to amend the provisions protecting the Supreme Court. In the case of St. Kitts and Nevis, the point does not arise in as sharp a manner as it did in Jamaica, because in St. Kitts and Nevis, unlike in Jamaica, the requirements for delinking from the Privy Council are basically the same as those for accepting the CCJ's jurisdiction. These requirements are in the first place governed by Section 38(2) and 3 of the Constitution, and these provide for the following requirements. First, there must be a delay of at least 90 days between the introduction of the bill and the beginning of proceedings in the House on the second reading of the bill. 90-day period of delay for debate. Second, there must be approval of the bill by at least 2/3 of the representatives of the National Assembly. 3, approval on a referendum by a majority of not less than 2/3 of the votes cast on that referendum. And 4, the assent of the Governor General. As the recent results in St. Vincent and the Grenadines show, it is not always easy to obtain approval in a referendum in our Westminster system of government. However, it must be conceded that in St. Vincent and the Grenadines, the referendum considered matters well beyond the court, and as such, the argument is possible that the verdict of the electorate was not directly on the court per se, in the same way as if the court was the only matter on the referendum. Furthermore, and this is very, very important, it is possible to argue that a referendum may not, as a matter of strict law, be necessary for St. Kitts and Nevis's migration from the Privy Council to the CCJ. This is because Section 38(4) of the Constitution expressly allows this country to reconstitute its highest court without parliamentary action or referendum, provided the government does so in agreement with the United Kingdom. This subsection would seem to allow both for the termination of appeals to the Privy Council and for the joining of the CCJ without recourse to Parliament or the referendum, provided that there was agreement with the United Kingdom. I want to read the sections in full so that we can have a debate afterwards if necessary. Section 38(4) says, the provisions in paragraph B of subsection 3 relating to the referendum shall not apply in relation to any bill to alter A, Section 99 of this Constitution, appeals from the High Court and Court of Appeal, in order to give effect to any agreement between St. Kitts and Nevis and the United Kingdom concerning appeals from any court having jurisdiction in St. Kitts and Nevis through the Judicial Committee. B, any provisions of the Supreme Court order in order to give effect to any international agreement to which St. Kitts and Nevis is a party relating to the Supreme Court or any other court constituted in common for St. Kitts and Nevis and for other countries also parties to the agreement. End quote. Assuming the amendment of the Supreme Court order catches all the possible sections of the Constitution that are relevant, it would seem to be the position that the linking from the Privy Council and its replacement with the CCJ could be accomplished under Section 38(4) without even legislative procedure. This would be a curious comment upon the Marshall Burnett case in which the Privy Council struck down the Jamaican legislation on the CCJ because of what the Privy Council deemed lack of adequate entrenchment in the Constitution of Jamaica. In the final analysis, the constitutional provision allowing St. Kitts and Nevis, and also Dominica, St. Vincent and the Grenadines, and St. Lucia to join the CCJ based on agreement with the United Kingdom places this country in a very different position from others in the OECS, such as Antigua and Barbuda and Grenada, where parliamentary action and a referendum are required. I must emphasize that my training, my association with regional institutions, and my status as a public servant completely disqualify me from giving advice to politicians as to the best route to be taken to reach the destination of the CCJ. I do feel confident that the people of this country will decide wisely. And whichever route is taken, I hope one day to join in the celebration of the final emancipation of the judiciary of St. Kitts and Nevis. Thank you very much.